Okay, we're live. Pretrial trial, finally. Okay, procedures following an arrest. This picks up the book. The text picks up the process at the point of an arrest. What it doesn't talk about is the surveillance, all the work that goes in prior to an arrest. Just be aware that there's a lot of legwork done before an actual arrest is made. So some of the important decisions about what happens to the defendant. Hearings, such as before the grand jury. Remember, I told you early on that there's two manners in which a case can be filed for criminal charges. One is the grand jury. What's the other one? Gotta know, there's two. The DA. But the DA files that via, it's a document. You'd think it'd be called the complaint, but it's not. It's called information. So the document that's labeled information is the actual charging document from the district attorney's office, charging a defendant with violating the criminal code. So it's a felony or a misdemeanor allegation. One way to file a criminal allegation, the grand jury. You see that on TV, the grand jury indictment. The other, more common, is the DA, and they file via information. The defendant's arraigned, enters a plea, informed of their constitutional rights, and considered by the court for pretrial diversion. We don't want to congest the court further by holding up less serious cases. Especially when we're talking drug-related cases. They have drug courts. They have community courts. They got all different kinds of little sub-courts that are established to try and pull some of that congestion off of the trial courts. If it's a serious case, absolutely it stays at the superior court level. They're already jumping into bail. So, and a defendant's arrested. Okay, the investigation's been done, or an officer has witnessed a felony offense. The arrest is made. At the point of arrest, my question to you, does the arresting officer have to inform the defendant of their Miranda rights? Frank's shaking his head. No, they don't. Unless you're watching television, in which case, yes. Actually, I love it. They're trying to get the restraints on and they're reciting their Miranda rights. Baloney. The only time that the defendant must be informed of their rights is if you're going to ask them a question. Are you going to question the suspect? Then yeah, you got to inform them of their rights. Otherwise, no. So we make the arrest. We take them down to the jail and we book them. We charge them for whatever offense it is. At the time of booking, there's a chart that indicates what the bail is for that specific offense. And right next to that chart is a list of bail bondsmen available to that defendant. It's a business. And I don't like it. I really don't like it. Because if you don't have the money to post your bail, you're going to jail. But if you have money, then you post your bail right there and never have to go see the inside of the jail. How is that justice? I don't get it. But that's what we're calling it, justice. So bail. What is bail? Nice description up there. Majority of criminal defendants released on bail prior to trial. There's several ways we can establish bail. But what is bail at its essence? Yeah.
It's an incentive not to run off before your trial.
Perfect. Incentive not to run off. Secure your appearance. Guaranteed. You're going to be there when the court tells you to be there. Want to piss off the judge? Don't show up for court. Yeah, they do not like that at all. See more bench warrants from angry judges? Yeah, that's not good, guys. Not good at all. So you could have had a really easy offense that you were dealing with, but you didn't show up for a court date. You don't want to hear it. Will issue a bench warrant, and he won't be kind. Yeah.
What is a bench warrant?
That's like a warrant, okay, that you have to go through the judge to get for an arrest. Well, the judge has that authority. He could issue one right from the bench. Failure to appear for a court-mandated hearing? Yeah. And you know damn well those deputies are going to be out there knocking on your door. There's no talking. You fail to appear, you get a bench warrant, you got to plead your case directly to the judge. Don't do that. Okay, so bail. It's something, a method that the court uses to secure an appearance. That's it. They want you to come to court. How they secure that appearance is where bail kind of differentiates. Is it going to be monetary? Maybe. Could be property. Could be your own word. Released on OR. Your own reconnaissance. I promise to appear on the court dates that the judge orders. Okay? Sometimes, most of the time, that's good enough. Especially for first-time offenders on lesser offenses. What if it's a capital case? Heinous murders, and you're the accused. You think you're going to see bail? Or even OR? Yeah, right. Yeah, no, you're not going to come out. Okay? It's a risk. Every time the court issues bail, they're taking a risk, a gamble, that the defendant will make those court dates as promised. So that's what bail is. The big fuss about bail is any time they use money to secure the release, people don't have that kind of money. So you have to go to a bondsman. Now remember, if you have $5,000 where you can write the check, give it to the judge to secure your own bail, you're cool. But if you don't, you got to go to a bail bondsman. $5,000, I want at least 10%. That's a $500 fee you're not getting back. That's what the bondsman's fee is to write that $5,000 check. Now you don't show up when you promise to show up. That's where the bounty hunter comes into play. The bondsman's going to sick them on you, and dog's going to come looking for you. He will get you, and they make pretty good money that way. Okay, so that's what bail is all about. Yeah. Frank.
Does it have to be? Does it have to be a $5,000 check, or could it be something more for $5,000?
Property. It's up to the judge. A lot of property gets lost in these trials. I worked a lot for courts and some attorneys, and Jim was his name. He loved taking property from his clients. And anytime they made promises to pay him and didn't, he kept vehicles, boats, property, land. He did pretty good, just taking things. And you're signing them over. Okay, that's just part of the agreement. You're signing it over to them. Okay, so that's bail. The 8th Amendment establishes that the bail cannot be used as a punishment. Can't be excessive. And it must be fair and impartial. We got a young black man right here, commits an offense. Then we got a young white male over here, commits the same offense, similar fact patterns. His bail is $15,000. This guy gets OR. Is that fair? Hell no. Okay, there are committees that sit to review these types of things. Usually they work for the grand jury, just to make sure the courts are being fair, because it is a constitutional right. Okay, you have the right, and through due process, there's several things you have rights to. One of them is fair bail, not to be used as a punishment. Questions about bail? Let's see. Well, did not establish absolute right. Let's see this case. I'm not familiar with this one. Okay, Stack Boyle did not establish absolute right to bail. It did set guidelines for state courts to follow. If a crime is bailable, the amount should not be frivolous, unusual, or beyond a person's ability to pay. Hey, do you agree with the guidelines? Okay, so what they're saying is, in this was a case before the Supreme Court. They said that bail is not an absolute right. Okay? But it didn't tell the court how the bail should be. What's the standard for bail? It still left it to the discretion of each individual court. So do you agree with that? Or do you think, no, the Supreme Court should establish a guideline? What are your thoughts? Leave it to the lower courts, or does the Supreme Court know best? We don't care today?
I thought there's always a gray area.
It is a gray area. Yeah.
I like to leave it to the lower courts.
So do I. Yeah, I don't want somebody that's not familiar with the case telling me what I have to do. Feds love that. Sorry. But the feds love doing that. I'd much rather just set a guideline, let the lower court interpret. Give them some discretion, don't tie their hands. And that's kind of what they did, so I like it. Okay, alternative bail mechanisms. Police field citation release. See a lot of this, those school resource officers, a kid's doing something wrong on campus, they just cite and have a nice day. Cite and release. Police station house citation. They actually bring you, maybe not in restraints, but they'll bring you into the station to have a conversation with you. Maybe cite you there, then cut you loose. Police pretrial jail citation and release. Pretrial court direct release by the court before your trial. And there's a lot of this. This is up and coming. And then, of course, the police court bail schedule. That's the most common. The up and coming one, you're held. And if you can't post bail, remember you got to go in for your arraignment. So within 48 hours, you're before the court. The court assesses the risk. And if they think you're at minimal risk that you will make your court appearances, they're going to release you on OR. Okay, let you go, promise to come back, and the more you show up for those hearing dates, the more likely the court's going to continue to work with you. So if you miss one, you're done. I've never seen anybody get forgiven for missing a court date. Judges get very upset. Types of bail. Full cash, writing checks right there in the courtroom. Deposit the bail. A surety bond. It's just that you're getting securance from like a bail bondsman. I don't know if they're up there. That's probably the lowest level. You go to a bail bondsman. You say, I don't have the money, because it's $100,000. He wants 10. I don't have 10, but here's the title on my car. So you're putting something down on it too. Remember, you're losing that title. You're losing the car, because that's his fee. And if he takes it, good for him. Conditional bail, we're going to establish bail, $10,000. However, if you come to your first court date appearance, we'll waive it. So you don't have to even post bail right now. It's up to you. Let's see what you can do. Conditional. Unsecured, that's pretty much OR. Release on your own recognizance. You're done. Just your word should be enough. But please, guys, if you ever get in trouble, make those court dates. Get a good attorney. Type of pretrial release. This is just a little chart of how often these types of bonds or for bail are actually used in percentage. Surety, you're posting some kind of insurance is the most common. It doesn't have the parents. When you're talking about juveniles, they have to go through bonds also. They have to post bail. A lot of times, the most common is they're released to their parents, custody of the parent, if there is a parent, and so forth. Question about bonds, types. Medium bail amounts by crime. I left this up there just kind of to show you the types of offenses and what's it going to cost. Violence, murder, wow, $1 million. Rape, 50,000. That doesn't seem right. Robbery, assault, and other violent. Property offenses a little lower. Drug offenses, public order offenses. $10,000. Driving related. Hit and run. Running stop signs. DUIs. You're all going to post bail on that. Pretrial detainees. People are either detained or cannot afford to post bail before trial, are kept in secure confinement. You're staying in jail. That's a nice way up there to say you're staying in jail. More likely to be convicted, get longer sentences. There was a study done. Same offense, same county, same everything. This person got out on bail, this one had to stay in jail. Throughout, I don't know how many cases it reviewed, but statistically they found that the person, the defendant that had to stay in jail was found guilty more often, and the punishment was more severe. That's interesting as hell. Anybody ever get to the point where you're working on a doctorate? That would be an awesome study to do. Okay, your dissertation on something like that. Bail has been heavily criticized as one of the most unacceptable aspects in the criminal justice system. There have been several attempts to reform the bail. Resulted in the use of release on OR, also efforts to tighten bail restrictions on the most dangerous offenders. On one end, we're trying to loosen the restriction on bail for the low-end offender. But on the other side, for the more serious offender, we want to tighten it up. We don't want them out on the street, possibly intimidating witnesses, interfering with the trial process. Don't need that. Okay, you kind of can understand how that would work. Not good. Pretrial services. Programs that provide a number of services to those released into the community prior to their trial dates. Determine which defendant can safely be released before trial, but they must participate in these programs. If they do, likelihood of failure to appear at arrest drops. Provide supervision for defendant. The likelihood of a defendant who participates in a pretrial program, even if found guilty, their sentence is going to be lighter, and the court is more lenient. Okay, this is for, I've seen it in domestic violence cases, either habitual drug users or people in threat of becoming habitual drug users, especially the latter, because the court wants them to succeed. The intent is to get them off the damn drugs. So they will send them, even up to 2 years, to a diversion program to get drug counseling. Now remember, the court doesn't pay for the program. The defendant has to pick up the tab. Okay, because if the court paid for it, that'd be our tax dollar. I'm not doing that. Okay, so if the defendant is serious and they want this program, it's up to the defendant and their counsel to find a seat and a program that will accept them. And then, of course, pay the fees. What do you think of that? Think of somebody, because I know we all know people that are either drug users or at risk of becoming a drug user. Imagine that person going to the courtroom and being presented with this alternative. You don't have to take it, but if you proceed, most likely you're going to be found guilty, and you will be doing some serious time. Or you can go to a diversion program. What would you recommend?
The diversion program?
Diversion. Anybody want to seize you? To hell with them. Go to jail.
Depends
Depends.
on how many times they've done it. They just might need jail.
There's always one case comes to mind. Depends how many times. Robert Downey Jr. How many times did he piss off that court? Same judge too. That poor judge, my goodness, pulling his hair out. What do I got to do to get through to you? I don't know. I'm just gonna say 4 or 5 times. Finally, they sentenced him to prison. He went to SADC. I was working in Sacramento when Downey ended up going to SADC. I was public information, so everybody's calling because they want to interview with this guy. Just deny. But that's what it took for him to finally open up his eyes. They had to put him in jail. He had to go through that process. And then finally he came out and he's doing much better. And he made Iron Man, so we all won. But he did. There's a success story. Hey, and remember, I spent all my younger adult life in prison, seeing these individuals. What a waste of humanity. Drugs. It's the worst thing I think that could have happened to our country. Just the drug addiction. God damn, it's terrible. Ruins families. So if there's a program that could help one individual, I'm all for it. I don't wanna see them in prison. They don't belong there. Okay, charging the defendant. I told you there was two ways. The indictment, and we call it presentment, but that's the district attorney. Okay, that's the information. And talk about reforming the grand jury, I don't think so. Grand jury, there's two types, and I'll tell you about them here in a minute, yeah.
Going back to the drug thing, do you
Yeah.
think that if they have literally any other crime related to the drug thing, they should just go to jail? Like maybe they
Not always, Frank, because remember, drugs are the driving reason why they committed these other offenses.
Yeah.
So they stole property, they did other stupid things they shouldn't have done, but it's because of the motivation was those drugs. So if you can negate the motivation, you eliminate all these other things. So it's case by case. Yeah. Okay, two types of grand juries. There's the one I sat on, which is bless you. You volunteer, you go in, it's a process, you sit on it for 2 years, and it's wonderful. Okay? The other one is more temporary on an as-needed basis, and it's only to hear certain cases. So you might call, the county will call a grand jury special session to hear, say like Scott Peterson's case. Okay, so they're gonna get members from the community, come in, evaluate the DA's information, bless you, and then either grant them the indictment or deny it. Okay, so there's a couple things going on with grand jury. And they want to reform them, not important. So the prelim, there's a judge and magistrate, evidence is presented, and there's cross-examination. Most defendants don't bother with a preliminary hearing. There's also called a 115 hearing, and here's why. During the preliminary hearing, hearsay is allowed. One officer, usually the arresting officer or the point officer in the case, presents all the information to the court, which is only counsel and the judge. The motivation is to convince the judge there's enough evidence to proceed with the trial. The defendant just sitting there wants to listen. What does the DA have on me? Now remember, there's full disclosure, not like you see on TV. Anything I'm going to use, I'm the DA. Any evidence I have against this defendant, I have to turn it over and present it to the defendant's counsel. Then there's a thing called reciprocity. Whatever the defense has, witnesses, evidence, they must also disclose to the district attorney to give them the opportunity to get expert witnesses to testify against whatever the other party is saying. You see these guys, we have a surprise witness. We just found this witness last night. We're gonna call, no, they're not. They're not gonna do that. Or we have a piece of evidence that we just found. Sorry. Now you can ask for a stay, a suspension in the trial, and give each side a chance to evaluate either the witness or the evidence. You can do that. But the judges want to keep those trials going. Remember the congestion. There's pressure to get these trials done and get them out. Okay, so that's the prelim. Could be called a 115 hearing. Hearsay is allowed. Yeah.
Did you get the definition of magistrate?
It's a judge.
Oh, okay.
Just another name for a judge. Judge or magistrate. I think there's a slight other difference. Look it up, it's in your text. But otherwise, it's just a judge.
Thank you.
Charging the defendant. Two different ways to charge. One is the grand jury, what we talked about. The other is the prelim, which is through the district attorney. You see, I've been talking about the two different ways to charge a defendant for a little while now. You think that's going to be important? You think? Yeah. Think you're going to see it later down the road? Yeah. You're going to see this in other classes if you stick with the AJ program? Yeah. This is very important you understand. The two ways you charge the accused, the suspect, with a felony. At an arraignment, the defendant is informed of the charges against him. They're read out loud. If they don't have counsel yet, usually they get counsel Yeah, at arraignment's where they're gonna get it. By the time they get to the prelim, they have to have counsel secured. Okay? They have to have it. A plea is entered at arraignment. And the most common plea you're gonna hear, not guilty. Even if the defendant wants to plead guilty and get it over with, the counsel's gonna say, no, you're gonna plead not guilty because they're not ready yet. They haven't even read all the information on the case. So they're gonna plead not guilty or no contest, which is the same thing as a guilty verdict. But why would I wanna plead no contest if it's the same as a guilty verdict? O.J. Simpson. Anybody familiar with that case?
Mm-hmm.
Yeah, O.J. Simpson. Entered a plea, no contest. No contest is still not guilty, but any of the proceedings during the court cannot be used in civil proceedings. And as you know, O.J.'s case ended up going to civil court and lost his ass there. Okay? So that's the difference. Whatever happens under a no contest plea is not used during civil proceedings. So guilty, not guilty, or no contest. Most cases never go to trial or are bargained out of the system. Here we go. Bargains can be made for a plea of guilty in exchange for, and this is kind of a swap meet. You're actually negotiating. Oh, I want $20, I'll give you 5. Okay, no, 18, okay, no, 7. And they're going back and forth and back and forth. Reduced sentence. DA presents an offer. 15 years, state prison. 5 years probation. Plus a bunch of fines. Defense is gonna come back and say no. The defendant, I've talked to him, he says he'll do 5. Then they're gonna scoff at each other, literally. And somewhere around 8 years to 9 years is where they're gonna settle. Both sides know this. It's a negotiation between the two parties. One thing is on the years of the sentence. The other is, of course, dropping the charges altogether, what doesn't usually happen during the plea. Lowering the charges. Instead of a second-degree offense, we'll lower it to a third-degree offense, which carries a lower sentence. And also, what the hell do we call this? Stacking. It's called stacking charges. In drug cases, the drugs is probably the primary, the motivating, driving factor why we're going to court is because of the drugs. But because of these drugs, they broke into a residence and it was unoccupied. That's another allegation, another charge. They caused $1,000 in damages. So that's another charge. They're going to stack it. They'll even say, well, he parked illegally while he was in the house committing the robbery. They're going to stack. So they want to stack as many charges as they can so that they can negotiate those away. Everybody knows it. It's just part of the game. Okay, so stacking the charges, and they call it lowering, or reducing, throwing some of them away. Substituting a negative charge for one with more socially acceptable connotation, especially when you're talking sex crimes. Well, if you're found guilty of this, you're going to have to become a registered offender for the rest of your life. However, if you plead guilty to this doesn't require registration for the rest of your life. Maybe it's only for 1 year. And I'm not familiar with what's going on there, okay? But it's something like that. You get the picture? Plea bargain. You notice I never actually even talked about guilt. Is the person guilty? We don't care. We really don't care. The DA only cares what they can prove. That's it. This person could be innocent, but the evidence is so strong. I know I can get a guilty verdict. Hell yeah, I'm gonna go to trial. Or we'll go through the negotiation process. Typical plea agreement results in a reduced charge for or favorable sentence recommendation. Another example of a plea bargain is a defendant charged with a sexual offense agreed to undergo surgical castration. And now it's chemical, but surgical. This is referred to as an example of ad hoc plea bargaining. Do you believe this type of plea bargaining is reasonable? Is it fair? Especially, it's a sex offense. Maybe not a rape, but it's a sex offense. The defendant is adamant that they're sorry, apologetic, and they're willing to go. I have a problem. I'm going to counseling. They've recommended, we've talked about surgical castration. I'm willing to do it, Your Honor. I know I need help, but I don't want to go to jail. You're the judge. What would you do?
Did you say stalking in the sentence?
Stacking.
Stab, I was like, what?
No, stacking. No, sorry. Yeah, stacking. You're just stacking a bunch of charges.
Yeah.
Anybody?
I mean, it's their choice.
Yeah,
Their
cast
choice.
away.
They wanna do it.
Sure.
Would you entertain that as the judge, Frank?
Like rapists, you
Oh, rape, that's a whole nother category.
I set an example and still put him in jail, but also do like half of the, like the other stuff that they wanted to get better as a person.
Half of a
Half,
custody?
like half
Castration.
jail,
How does that one work?
I don't know, I'm the judge and I'll figure it out.
You'll figure it out, okay. There's I don't have the videos loaded into this presentation, but I have some videos of one judge in particular. This guy is the most creative judge I've ever seen. Yeah. Wait, have you seen the video?
No, I haven't.
Oh,
but
okay.
it's-
This judge, he had, this broke my heart. It was a lady was abusing her dogs, leaving them in the house unattended to. They were skeletons almost. Wouldn't feed them, wouldn't take them out of the house. They reeked in the house. So they took her to court, and the judge found her guilty. He said, for your sentence, I'm gonna make you go and work in the city dump, in the filth, in the garbage, in the stink. So you could, of course those animals were taken and they fully recovered. But I want you to experience what those animals went through. Put that up in the closet. Yeah, let her rot out there, that nasty note there. But that was just one example. Oh God, he had a couple others. The guy was good. 2020 even did a little piece on him. He was that good. But anyway, the judge has a lot of discretion. You know, with lower offenses. Penal code these days on the more serious offenses, judges' hands are kind of tied. They have to do what they have to do. There was something else I wanted to share. Overall costs of criminal prosecution are reduced. These are some of the pros. Okay, I want you to think of the pros, and then we're going to talk about the cons of plea bargaining. These are the pros. The court is less congested. One DA, deputy DA, can handle maybe a dozen cases because they're only pleading them away. Versus if he has to go to trial. That trial's going to take him 2-3 days to get done. So he can do more work. Yeah.
I forgot my dog's having an appointment, so I have to see that.
Go. Good luck. Hope it all works out.
Um,
Okay, the administrative efficiency of the courts is greatly improved. We can get these cases through. Now remember, part of the due process is a fair, impartial, and timely hearing. If we're having trials and everybody's going to trial, your case is going to be at least a year out, bumped out, not within that 60-day window. You're not going to like that. Prosecution can devote more time to more serious offenses. Okay, why go to trial on these lesser offenses when I know I could plea them out and I could focus on the more heinous crimes? Spend time there and get those prosecutions. The defendant avoids possible detention and an extended trial may receive a reduced sentence so that the defendant wins. Okay? And resources can be devoted to more efficiently to cases that need more attention. Resources, money, evidence costs money to test it, evaluate it, process, present it. For every single case, it is expensive. So these are some of the pros. If we can plead these cases out, we're saving money. We're being more efficient. We're reducing congestion. Yeah, I think we can see that picture and it sounds nice. Let's look at the other side of the coin. Defendants have to waive their constitutional right to trial. They're agreeing to that. Allow dangerous offenders to receive lenient sentencing. That happens sometimes. Danger that an innocent person will be convicted of a crime. That happens more often than I care to admit. Because I know I didn't commit it, but the evidence is stacked against me. And I know damn well, I'm convinced that if I go to trial, I'm gonna lose. And if I lose, I'm going to prison for 15 years. I can't afford that. The DA is offering 5 years. Do 1 year county, 4 years suspended, the rest on probation. They're sweetening this deal. Think about it. Would you take that plea bargain? Probably not. Probably. During jail, they even sweeten it up. While I'm incarcerated, the judges agreed to let me work. So I can go out, I can keep my job. I can continue to support my family. But I have to be back in jail at 6 o'clock and on weekends. I get out at 6 in the morning so I can go to work. I have to be back by 6 in the evening. And then on the weekends, I'm in jail for 1 year. They do this. Not a bad deal. But I'm innocent. I know I didn't do it. Would I take the deal? Think about it. Would you? Who wouldn't?
You got a good lawyer.
That's the best deal you got you so far. The evidence is stacked. And you know it. Hell, you'd find yourself guilty. But you know you're not guilty. Would you roll the dice, go to trial? I said, you would. You would.
Yeah.
Good for you.
How is there so much evidence if you're not guilty?
Oh, DNA, yeah. That damn DNA. It's usually somebody they knew, they had visited, but they didn't do it. They're being accused of, somebody else did it, but it sure looks like this person. There's some cases out there. Yeah. Wrong place, wrong time, yeah.
So the witness to identify a whereabouts. but
Similar.
not to-
But you don't have a witness. You don't have an alibi, a strong alibi. And the person that they have on video, similar to you. But you know it's not. You're even looking at the video. You're going, damn, because you know it's in shadow. It's not a frontal. But damn, that looks like me. But you know you weren't there. Where were you? I was at home watching TV by myself. I was asleep. Prove it.
There's a documentary on Netflix where a guy got found guilty for a crime I think his brother did, and his only proof was he was at Dodger Stadium. They showed a show. I think it was like Curb Your Enthusiasm.
Yeah.
And his lawyer, good lawyer, found that videotape and he saw him on.
He got lucky.
Yeah, he got lucky. He was still in jail. He was in jail though during this time, but his lawyer was kind of
Working on it.
Yeah.
And, I'm telling you, most people would take the deal. I don't know. I still can't answer that one because I don't know what I would do. But think about it. So, with all of this, and remember, you're admitting, even though you're innocent, you have to admit to the guilt. Yes, Your Honor, I'm guilty. Sometimes they'll waive where you have to say why you're guilty, but that's also negotiable. It is a guilty plea culture. They've even come up with a special plea, it's called the West plea, for a defendant to say, Your Honor, I'm only pleading guilty because of the plea bargain. How is that justice? It's called the West plea. They named it. The court knows this is going on. We know what's going on, but we've done nothing to change it. That's plea bargaining for you. Okay? Problem with false confessions are the worst. You think, oh no, we got a confession. You got crap. I want evidence. All right. Why do innocent people confess to a crime? Duress, coercion, intoxication, diminished capacity, mental impairment, ignorance of the law, fear of violence, actual infliction of harm, the threat of a harsher sentence, misunderstanding the situation. It doesn't have it up there, but I've seen too, they're looking for notoriety. Okay, people will come in and confess to these crimes just because they want to be in the limelight. Yeah, I did it. Police during investigation, they're not that stupid. They withhold evidence. Always. They'll present certain things to the media and the public, but they always withhold specific details of a crime. just in case some nut job wants to come down and say they're guilty and confess. Okay? That's how they weed out the nut jobs. But why would somebody want to confess to something they didn't do? There it is there. Legal issues and plea bargaining. Effective assistance of counsel. Counsel is one of the most appealable issues in any case. Pleas must be made voluntarily. Prosecutors' promises must be kept. Defendant must keep their promise. Due process rights must never be violated. Guilty pleas from people who claim innocence are valid. That's the West plea. Use of plea bargaining statements at trial. Flawed advice from a defense attorney that leads to rejection of a plea deal can be the basis of ineffective assistance of counsel. IAC is the acronym for ineffective assistance of counsel. Okay, plea is a negotiated agreement between the defense and the prosecutor. It's a deal that they're agreeing to, but it needs that rubber stamp, the seal of approval. That comes from the judge. So both sides are negotiating. They think they've reached an agreement. They go before the judge in chambers, it's not out where everybody sees it, and they hash it out. They just hash it out. And if the judge is in agreement, then he says, okay, let's do it. Once they acknowledge all parties are on board, they go back into the courtroom. Defense attorney tells the defendant, yeah, we got the deal. They put it on record. And it really, I've seen, it's like a rehearsed play. The judge will be saying, okay, so we're gonna open up with, I'll read this, and then you're gonna say this, and then you're gonna do this, and then I'll say yes. And then we're gonna question the defense. Really, it's scripted. Hopefully we're gonna talk about this next thing on the PowerPoint, but I haven't seen it yet. We talked about the defense, we talked about the DA, we talked about evidence, we talked about plea bargaining, we talked about guilt, we talked about innocence. What haven't we talked about?
The person who committed the crime.
Well, he's the defendant.
Oh, yeah, oops.
I thought you had it though. The victim! Where the hell is the victim in all of this?
I mean, depends on the case. The victim could be the murdered, could be there, or they
Well,
could
the
be-
family represents the deceased, yeah.
Or they could be there in cases of rape, or maybe in civil cases as well.
Yeah, usually there's a victim. Hopefully they're alive, if not, the family will be there in their stead, yeah.
Typically, if there's a plea bargaining, the victim sometimes doesn't even need to be there, right? Like
I didn't hear the last part.
The victim doesn't even need to be there in the court, like sometimes a plea bargaining, you're just moving them along, so.
They do not have to be there, you're right. But if I'm the victim, sure the heck I'm gonna be there. I want justice. Remember, all these pleas, these deals are being cut. They're being negotiated in chambers. The victim is never consulted. Not once. So we've rehearsed what we're gonna say. We go to the courtroom. We're getting ready to put it on record. The judge will ask, is there anyone that would like to speak before I issue a sentence here? Usually a victim's gonna stand up. It's called the victim impact statement. By law, they're allowed to come forward and either read the statement themselves or have somebody else read it for them. Or they could just hand it over to the court reporter, put it on record. It's better if they read it themselves. So they're gonna get up there and they're going to cry and say why they were violated, they plead the court for justice, and they're really pouring their heart out, and it means nothing to the court. Remember, the deal's been cut. It's been stamped. So why are we going to do all these theatrics? That's why I urge you, go see a trial. Preferably where there's a victim and they come up, make a statement, and then you're gonna be sitting there going, dummy, whatever you're doing doesn't matter, because the case has already been negotiated. I hate it when that happens, but that's the way it works. Where is the victim? The role of the prosecutor. Few states, yeah, they put some restrictions because prosecutors get a little carried away. Court will not accept a guilty plea unless the defendant has been properly advised by counsel. The court has determined that the plea is voluntary and on factual basis. And they recite a whole bunch of things. And the defendant has to acknowledge each. They're waiving the rights to trial. They're intelligently, voluntarily, and factually waiving these rights. And it's a whole thing that they have to do. The role of the defense counsel: advisory, explanatory, informative. The role of the judge: not straightforward, should be supervisory, or should they enter into negotiation themselves? I've seen the judges get involved in negotiations only when the process is at a stalemate. That's my experience. They're close to a deal, but they're not giving in certain areas. I have seen the judge be persuasive. Come on, guys, you could do a little better. You could accept this. And actually, like a used car salesman. The victim: no role, not required. How does that make you feel? You're the reason for the party. You're the victim, and they don't care about you. No role. Although plea bargaining has been criticized, efforts to control it, they don't work. Jurisdictional safeguards: judge questions the defendant. This is at the local level. Defense counsel is present. Open discussion of the plea. Full, frank information about the defendant. There's too much incentive not to use plea bargaining. It's something that we just have to learn to live with. It is not going anywhere. We can make some changes to make it better, make it more effective, make it fair to the victim. Diversion: we talked about diversion. You do this instead of doing that. And there's several different types. The book does a good job of outlining it. What types? We'll skip that one. Let's get to the trial. We've got a few minutes. Open public hearing designed to examine the facts of a case brought by the state against an individual. Remember, only the state, only the government can bring allegations of a criminal offense against an individual. An individual cannot charge another individual with a criminal offense. Most formal trials heard by a jury, although some request a bench trial. Highly recommend, if you ever get in trouble, the hell with the jury. They're a bunch of idiots in my experience. Go get out of jury duty. I'm having a bench trial. I'd rather have somebody that knows the law let me know where I stand. But that's me, my preference. The trial: these are just the parties. The counsel: speedy trial, public trial, convicted by proof. That's the standard, guys. On this PowerPoint, this slide, proof beyond a reasonable doubt. You got 12 jurors. All 12 must reach the same verdict: guilty finding. One juror can throw the whole thing. Hung jury. Okay, you have to have all 12. Proof beyond a reasonable doubt. This is a really nice chart. I try to blow it up as big as I could because it kind of delineates the process on one page, and it's in your book. Void diary. I didn't talk about void diary. That's jury selection. Okay, we didn't talk about jury selection. That's a whole nother thing. Void diary. Prosecutor's opening statement. That's actually a real good slide for you. Anybody know how the jury works? How we panel a jury? You haven't gone? It's an interesting process. I've gone a few times. I'm excused every single time. Sometimes I was even involved in the case. That was a joke, but I still had to sit there and wait to be excused. You get them through the voting registration and driver's license. The jury commission gets the information from these resources, and it's just a process. How do we call it? Just random, and these notices go out. And if you get the notice, You could go, or you could ask them to, because the time isn't right, you could ask to suspend it a little bit, but you go. So that's how it starts. You have to sit through all the training, and it takes about an hour, the do's and the don'ts. Then they take you in pools, jury pools. On your badge, it'll have a number or a letter, and you're part of that jury pool. So you say you're in jury pool A. You're assigned to courtroom 3. So when the bailiff comes to get you, jury pool A, follow me. You get up, follow him. You go, you sit down in the gallery, just like this. They have a ball with little people, like bingo. Right? Bingo. Yeah. And there's numbers in there that match your badges that you're wearing. And they will call out jury member 113. If that's you, you stand up. Don't say bingo. But you stand up, you go and you have a seat. Okay, you have a seat in the jury box. And you'll be jury number 1. They'll tell you. You're jury member number 1, have a seat, please. Jury member number 2, have a seat. 12 is required. They usually have 15 on just any cases, because they got 3 standbys. The alternate jury members, they also sit in the jury box. They listen to the evidence. They take notes. They do not participate in deliberation. They're there just in case something happens to one of the 12. So if they have to be excused, an alternate's called in, and the trial just continues smooth without any glitches. The prosecutor, opening statement. The DA can make an opening statement or hold it to the end. It's up to them. Defer. Okay, so they get their statements. They start calling witnesses, they start presenting evidence, then they have direct exam, then they got cross, redirect, recross, back and forth until the witness is excused. Okay, witness goes away. Finally, the DA will rest its case. Say, that's all we have, Your Honor. Defense counsel, do you have anyone you would like to call at this point? Most of the time, no, they're fine. They don't usually do what's called an affirmative defense. They just want to poke holes in the DA's case. So they rest. Then they do closing arguments. Then the jury gets instructions from the judge. These are instructions that are agreed on by counsel, specifically for this trial. So the judge sits there and reads off all the jury instructions. Could be up to 50, 60 individual instructions. The booklet is handed to the jury or the bailiff. The bailiff gives it to the jury. Once they're sequestered, they're put away. They get to deliberate. That's a lot. They get to deliberate. Render a finding, guilty or not guilty. Not innocent. There's no innocent here. It's either guilty or not guilty. Let's say that they come back with a finding of guilt. The judge thanks them for their service and excuses them. Then we move on into the sentencing phase. I don't know if that covered everything there, but that's about the way it goes. Questions? It's a lot, huh? That's a lot of information to digest. The book does a good job of covering it. Pretty much everything I told you. Yeah.
How long does a jury have to deliberate? Say there's a hung jury.
Mm-hmm.
Eventually, will they just? What happens?
It's up to the judge.
It's up to
It's
the
actually a
judge.
good question, yeah. Maybe they're split 11-1, because the judge wants to know. If it's hung, where are we at? They'll tell them we're 11-1. So go back, rehash it. Talk it, deliberate again, rediscuss. They come back, say, where are we at now? We're at 9-3. Who's not looking good? Yeah, let's go back again. Back to now 10-2. This is after a full day of deliberation. It's up to the judge. He'll talk to the prosecutor. What do you think? Prosecutor might just say, let's call it. Hung jury. Good question. It leads me to the next thing. As a defendant, you just went through a whole damn trial. You want to go through this again? Yeah? No! Come on, no! So, when the judge calls it a hung trial, we're going to excuse the case. You want it dismissed with prejudice. Okay, with prejudice. That tells the DA you can't file charges again. You can't go back, find new witness, and it's not double jeopardy because it was a hung jury. But if the judge says, I dismiss it with prejudice, now you can go home resting. If he says, no, I'm gonna dismiss it without prejudice. It ain't over. The DA's done a good job of convincing the judge. I think I can win this. I just need a little more time. There's a few more witnesses out there I can do. But the judges are gonna be pretty upset. Say, well, if you could have done it now, why didn't you do it then? There's a lot to consider, a lot of persuasion going on. But yeah, you see what your question amendment?
So it's not double jeopardy if you're dismissed without prejudice?
Without prejudice, yeah. That gives the DA the right to refile, regroup, and file charges again. Okay? That's all I got, thank goodness. I was hoping I was gonna get through this one. This is a long presentation, guys. It's a lot of information. Please review your text, or if you don't have a textbook, I don't know why you wouldn't, but maybe you don't. Review my notes. Go over the presentation. There's a lot of information that you're gonna need from this chapter. Okay, if you have questions or need to see me, just sit tight. I'm gonna be here for a while.